Hello everyone, this is Compass, navigating legal studies for your mission. This video is a legal essay practice for law students and bar exam takers. Today's topic is motion and preclusive effect. Problem: XYG Corporation, a citizen of state G, manufactures electronic gadgets. The gadgets are distributed by Gadget Incorporation, a citizen of State W, to various retailers throughout the United States. Plaintiff, a citizen of State W, purchased an XYG gadget from a local retailer in her town. After using the gadget for a few days, Plaintiff suffered severe burns when the gadget overheated and caught fire. Plaintiff filed a lawsuit against XYG in the Federal District Court located in State W, invoking the court's diversity jurisdiction. Plaintiff sought $150,000 in damages, claiming failure to warn and sale of a dangerously defective product. Under the applicable state law, a manufacturer's duty to warn is deemed fulfilled if a proper warning is affixed to the product when it is delivered to its distributor. The distributor's duty is fully discharged if the warning is affixed when the product is delivered to the retailer. State law also allows both manufacturers and distributors to be held strictly liable for selling a dangerously defective product, even if the manufacturer has properly warned of the risks. After extensive discovery, XYG filed a motion for a summary judgment on the failure to warn claim. XYG provided affidavits from its employees and Gadgets Incorporation, stating that a proper warning label had been affixed to the gadget when it was delivered to Gadget Incorporation, and again when the gadget was delivered to the retailer. Plaintiff submitted an affidavit asserting that the gadget she purchased had no warning label attached. The federal court granted XYG's motion for summary judgment on the failure to warn claim and entered judgment against plaintiff on that claim. Plaintiff did not appeal the decision. Soon after, XYG and plaintiff settled the dangerously defective product claim for an undisclosed amount. A few months later, plaintiff filed a lawsuit in the state court of State W against Gadgets Incorporation, asserting the same two claims: failure to warn and sale of a dangerously defective product. Gadgets Incorporation filed a motion to dismiss on the grounds of a claim and issue preclusion. Problem 1. Does the federal court properly grant XYG's motion for summary judgment on the failure to warn claim? Second, should the state court give preclusive effect to the federal court's judgment and dismiss plaintiff's claims against Gazette Incorporation? Question number 1. The issue is whether the federal court properly granted XYG's motion for summary judgment on the failure to warn claim. A motion for summary judgment should be granted if the moving party demonstrates that there is no genuine dispute of material fact and is entitled to judgment as a matter of law. The non-moving party must then counter the motion with evidence to create a dispute of material fact. XYG submitted affidavits from its employees and from Gadgets Incorporation attesting that a proper warning label had been affixed to the product both when it was delivered to Gadgets Incorporation and when it was delivered to the retailer. Plaintiff contested the motion with her own affidavit, asserting that her purchased gauzes lacked a warning label. However, under the applicable state law, XYG's liability for failure to warn is discharged if a proper warning was affixed at the time the product was delivered to Gadget Incorporation. Plaintiff's affidavit did not address whether the warning label was affixed at the time, and thus there was no genuine dispute of material facts. As a result, the court correctly concluded that XYG was entitled to judgment as a matter of law. Therefore, the federal court properly granted XYG's motion for summary judgment on the failure to warn claim. Question number 2. The issue is whether the state court should give preclusive effect to the federal court's judgment and dismiss plaintiff's claims against Gadgets Incorporation. For claim preclusion to apply, there must be a final judgment on the merits. The parties must be the same or in privity, and the claims must arise out of the same transaction or occurrence. For issue preclusion to apply, the issues in the two actions must be the same, and the party against whom preclusion is asserted must have had a fair opportunity to be heard. Claim preclusion. Gadgets Incorporation seeks to prevent plaintiff's claim based on claim preclusion. In order for claim preclusion to apply, the parties must be the same or in privity. Here, the parties in the federal case were XYG and plaintiff, while the parties in the state case are Gadgets Incorporation and plaintiff. Gadgets Incorporation is not in privity with XYG as they are separate entities with distinct duties under state law. Thus, claim preclusion does not apply in this case. Issue preclusion. Gadgets Incorporation also asserts that issue preclusion applies because the federal court ruled that a proper warning was affixed to the gadget at the time it was delivered to Gadgets Incorporation. However, the issue in the federal case concerned whether the warning was affixed at the time XYG delivered the gadgets to Gadgets Incorporation, not at the time Gadgets Incorporation delivered it to the retailer. The issue in the state case is whether the warning was affixed at the time Gadgets Incorporation delivered the product to the retailer, a distinct issue. As such, issue preclusion does not apply. Therefore, the state court should not give preclusive effect to the federal court judgment and should not dismiss plaintiff's claims against Gazette Incorporation. Let's wrap up this session by revisiting the key rules. A motion for summary judgment should be granted if the moving party demonstrates that there is no genuine dispute of material fact and is entitled to judgment as a matter of law. The non-moving party must then counter the motion with evidence to create a dispute of material fact. For claim preclusion to apply, there must be a final judgment on the merits. The parties must be the same or in privity, and the claims must arise out of the same transaction or occurrence. For issue preclusion to apply, the issues in the two actions must be the same, and the party against whom preclusion is asserted must have had a fair opportunity to be heard. This table compares claim preclusion res judicata and issue preclusion collateral estoppel to highlight their differences and applications. Hope this table helps you understand the two concepts. Thank you for watching. See you in the next video. God bless you.